Welcome back to our Technology Startup YouTube video series. My name is Christopher Neufeld of Neufeld Legal, and I am a tech and business lawyer. And in this particular YouTube video, we're going to be discussing the aspect of non-disclosure agreements, otherwise known as confidentiality agreements. Now, for a tech startup and a new tech business, you're going to have to come outside of your own personal bubble to advance the business. And as you're doing this, you're going to bring in other people. And these people have the potential of stealing, drawing upon your technological advances, your ideas, your concepts, such that you need to start looking right from the outset as to protecting your technological concepts. So what do you need to do? One of the first things you need to do is have a non-disclosure confidentiality agreement put in place and have them sign off on it in advance of their being provided with insights and information as to what your business is doing, what your technology is intended to achieve. This allows you to retain control and to have a legal argument going forward that you are the innovator. Naturally, there's going to be other agreements that you're going to build off of that as you bring people in, and the non-disclosure confidentiality agreement should not be the be-all and end-all. Nevertheless, it is a critical first step in the process. So this agreement is going to have to be signed off by the other party, such that they acknowledge that what the concepts you're bringing forth, the information that you're bringing to them, is your proprietary information. But beyond having a simple piece of paper there, you also need to have additional documentation to support it. Because what tends to happen is people then can manipulate when they received information, when they heard about it, and the whole concept. So the first part is the agreement. But equally important is having an electronic record, often provided to a third-party holder, such as your lawyer, who has information reflecting the advancements that you are making. And then you have to also be providing the recipient party with a basis as to what you are showing them. You want to have some record between yourself and themselves as to here is the innovation, the new approach that you're looking to take, the insight, the technological advance that you're making. And you want them to have in some way sign off further to the agreement that this is something new and innovative that came exclusively from yourself. If they're saying, you don't want them to say afterwards, I already knew about it, I would have known about it, I would have found out about it. Instead, you start off with the one agreement. You present that to them. Then, and at the same time, you have your technological advance saved up, so there's a hard record of it. Then when you sit down with the individual and you present the basic framework of what you're looking to proceed with, you get them to sign off an acknowledgement as to the innovativeness and the advancement that this is. If they say they already know about it, well, then you have a conundrum that you have to deal with, because then you have to figure out how much of this innovation are they claiming to already know about, and can they define it such that you can provide them with further information moving forward, lest you will find yourself in a position where they say, this is already known to me, and this is not something that's new and innovative to myself, and I'm not going to be taking on an obligation to keep it confidential and not build upon it. So these critical steps need to be taken. and you're going to constantly be putting it together and keeping a record of it and getting sign-offs both by the individuals who are being shared the information, as well as potentially your own legal counsel, who can act as a guide and an arbiter for yourself as to how much you disclose and when you disclose the information, and to ensure that you're properly protected. Now, a lot of this stuff can be done by yourself without any legal support, although it is always strongly recommended that you engage a lawyer when it comes to more sensitive information and in general. I understand that as a startup, there's not a ton of money out there. Nevertheless, there are critical agreements, there are critical decisions, critical engagements that you need to be making, and you need to have legal counsel on. That is why in most scenarios, it is recommended that you engage knowledgeable legal counsel. And we cannot stress this enough. Nevertheless, that remains your decision as to how you move forward. And what we will try to do with this YouTube video series is provide you the core tools. So even if you don't engage legal counsel, you have an understanding as to what you should be looking to do and how you might attempt to better protect yourself from a legal standpoint and protect the technology that you're looking to monetize and commercialize to your successful financial benefit. Well, we hope you have found this YouTube video enlightening and informative. If you liked the video, subscribe to our channel for future YouTube videos for tech entrepreneurs as they advance their startup businesses. And you also provide us with comments so we can continue to develop more informative YouTube videos that are akin to what you as a tech entrepreneur are looking to address from a technology and business standpoint. And as always, we're always here to help you with your legal issues and legal advancement. Although naturally, with everything, time is money, and to get appropriate legal advice, you got to be willing to spend to advance your own particular business interests, given that effective legal counsel can make a lot of difference to the advancement of your new startup tech business. Thank you.